assistance was really necessary.
Who chose these law clerks in the earlier years?
In the early days, we had a group of like 3 judges, and I was one of them. And we would interview a cast of thousands, and then knock them down to a reasonable number, and then we would hire them, and they were kind of just assigned to judges. As time went on, each judge then, when it became 1-for-1, they would interview their own. And I think actually in Fairfax, up until recently, they had maybe a committee that was that wheedled the number down, but then you would interview your own.
What were some of the characteristics that you looked for in a good
Well,
lawyer?
I can tell, and it's probably better if I talk about that kind of how I do it for my own, and I can do it on the circuit court, but I really did it when I was on the appellate court. And I learned a lot of lessons in hiring law clerks. As a judge, you're a little bit isolated in life, and so it's very important that your own staff be somebody that you're comfortable with, whether it's a secretary, an administrative aide, or a law clerk. And just hiring somebody that's number 1 in their class is a big boo-boo as far as I'm concerned. The worst law clerk I ever had was a woman who was number 1 in her class, and she was a loser. It was just a big mistake, and I learned from that.
What was the mistake?
Oh my God, she had a terrible work ethic, and it was not a good fit, and I think I sort of got stars in my eyes. Well, obviously this is a very bright young woman, and it was not a good fit. And what I really came to look for was someone who, number 1, is smart enough, but who had a feeling for the law, that this was something not just to pass your time on until something better came along, but that I could use as a continuation of their legal education, because that's what a law clerk is. You get an extra year of legal education with a judge who hopefully knows more than you do, helping you along the path. And so that personal relationship of wanting to be able to talk to them, to enjoy, their company, is important. And you talk to them about things, what their likes, what their dislikes, but almost like the conversation we've had today. And then I began a long time ago giving them a writing assignment. I don't want to see something they wrote for law school. I gave them a writing assignment, gave them 2 hours, and had them write for me. And that separates, if you'll pardon the expression, the men from the boys. Because if you can't write a coherent sentence, then you shouldn't be a law clerk. The idea of having somebody because with my law clerks, the way I used to work both on the trial bench and on the appellate bench is, we talked a lot. We discuss cases. These are issues that I see that are out there. What do you think about this? I think you need to help me figure the law on this one. See if there's any law that's someplace else. It's not like you spend every waking moment together, but you're together a lot. So I think whether you're comfortable with them or not is an important part of it. The other issue is the work ethic. Most of my law clerks never worked any longer than the normal work hours, whether it's 8:30 to 4:30, 9 to 5, whatever it is. But if I needed them to work longer, I expected them to do that, and we kind of always made that clear. If they had, and I actually kind of had a couple of innovative things with law clerks. I've had law clerks, and I found I like to hire them for 1 year with the second year at my option, which is really great because the first year you've trained them. I've had law clerks that had babies, and we worked out a schedule that allowed them to continue to work and yet, find the right child care. I remember back to when that was me. I had a law clerk whose husband was at UVA and getting a tax degree. And we worked it out so that she was in the office with me Monday, Tuesday, Wednesday, unless she left Thursday, and was able to spend 4 days at UVA and use their library. And you can do things that work as long as the work is good. But I have to say, I really, really feel fortunate that I've been able to work and mentor all these young people. They're probably, I don't even know how many of them there are now, 30 over the years. because I learned so much from them, and I hope that they learned, something from me. But our law clerk is a very important part of a judge's life.
Because you were so well read and you had an interest in literature and history, did you find that you were kind of looking for some of those things as well? Perhaps not the same interests, but the fact that they were well read and well rounded.
Yeah, I mean, I really was, and I like people that like basketball. I like people that play tennis. I only had one law clerk I think that played tennis. That was. I remember Hugo Black, who actually, his house is about 2 blocks up the street here. They said he used to always, and I think in those days the Supreme Court just had 2 law clerks, and he always made sure one of them played tennis. I wasn't ever able to get that done. But yes, and I think anytime you're sort of dealing with those kind of issues, you want to find somebody that you think has a breadth of interest that's out there. But I really was very fortunate in my law clerks over the years. And I didn't have that many secretaries or administrative assistants. They pretty much stayed, I guess maybe I had 3 over the time. So, that was a nice continuity there too.
When you had to write your decisions, what was the process that you liked? Did you have a routine way of going about?
You mean on the trial court or on the...
First on the trial court and then on the appellate court.
Well, it was really, I have to say, on the trial court, really primarily you're calling balls and strikes every day. And if you try and write a decision on every case, you just end up in a hole. So what you try and do, in a jury trial, that you're not writing a decision, or in most civil cases, hopefully you can give them a decision fairly expeditiously, because you just can't possibly do the work right and spend 5 days a week writing erudite opinions. It's unfortunate, and you do end up writing opinions. I have a whole box full of opinions that I wrote while I was on the court. But they were always, as a trial judge, you're trying to fit them in with the next case that comes in the door, with the next whatever. And I tried to just be very direct and give them the answer without trying to really lay out the law for generations. This is what it is in this case. These are the cases that I think apply and whatever. So they tended to be more, I would say, truncated. You really, what a trial judge should do is give the parties an answer to their case. That's what your job is. And if you can't do it from the bench, then you need to do it quickly as possible, in a reasoned but not, a war and peace tone either. So that was sort of the way that you approached it. And I used my law clerks there, but not as much as on the appellate bench, because that's just a different thing. You're writing law that other people are going to take and have to apply to other cases, and so there is a difference. Maybe there shouldn't be, but for me there was. I just felt like my real job as the trial judge was to decide that case and get it done, hopefully right. Usually you're right, but sometimes, I've been reversed. I've been reversed by the Court of Appeals and by the Supreme Court too. But you just got to give it your best shot as a trial judge and not worry about what happens afterwards. If you do, then you can't do the job you're doing. I think on the appellate bench it was very different, because, you don't have to say overruled, hearsay, whatever. You can kind of think about it, and you have the issues laid out for you, and you can, by the time you've read the briefs and the appendix, you know as much about the case as the lawyers ever do. It is a much more intellectual endeavor. You're not calling balls and strikes every day. You're thinking about the process. You're thinking, cases are fact-driven. And you just put them into the law as it exists. If the law is unclear, then you try and make it clearer. But the process would be, when the cases would come in, let's say on the Court of Appeals, we'd have maybe, and I'm not talking about all the petitions and all the other things, I'm talking about the cases for hearing. And let's say at each panel there's 7 cases. Or maybe that's probably, let's say 8 cases. Out of the 8 cases, let's say 9 cases, I would be writing 3 of them, supposedly. My other 2 colleagues would be writing 3. that may change after hearing, because maybe I'll be in the dissent on one and somebody else will be in, but generally you have 3 cases that are assigned to you. I would work with my law clerks on my cases. I did not have my law clerks do the other judges' cases. I do the other judges' cases. And then if I need something done on it, I'd tell them to look it up. But my law clerks would do mine. And first of all, I would read through the briefs first. And I would just say, you know, these are issues that appear to me, this, I need help on this, I want you to research that. And then I want you to give me a bench brief citing to the record. Check every site that's in there, citing to the record where it is. They would give me back a bench brief. Then I'd go through my cases again, probably have them write up a potential fact pattern. And then when it came time to write the case, I write the case. And then we go back and forth with it. You know, I look at the law. I should have all the law there. I'm able to plug it into what it is. People use their law clerks in different ways, but I primarily wanted to arrange it in my way of doing it. And I had my own way of doing it. I mean, if you read my opinions, they're different than Jimmy Benton's. If you read somebody else, they're different than mine. But I would set mine out one way, and then that, you kind of had my own stamp on it. But I would say I would try to be shorter rather than longer. Sometimes you can't because there's just too much stuff. But I think the main thing a judge ought to do is not editorialize if possible. Once again, give the answer and hopefully guidance on what the law is. But in terms of how we did it, then we would send the first draft out to the panel. They would make comments on it. Have you thought about this? I disagree with that. You know, whatever. Then it would come back to me. I'd look at it. Maybe I'd make some changes. Maybe I wouldn't. And I'd tell them why I wouldn't do it. We'd send it back out again until we can get something that everybody signs off on. But in a 3-judge panel, a 3-judge court, it's very collegial. You have to. We do a lot by email, but I like to pick up the phone and talk if there was any kind of issue on it. But mostly the things would go pretty smoothly. And I felt it in for my cases, I wanted to make sure there was never any question that anybody asked that I couldn't answer. So I think, and I'm sure the other judges felt that way too.
It seems that you used your law clerk or clerks primarily as researchers. Did you, though, engage them in any debate or discussion on those issues? And
sometimes, I generally, when I would read the briefs, I generally have a feeling on either how the case was going to come out, what the real issues were in it. They may have 20 issues, but there's really only 3 that mean anything. Those might be something I would say to the law clerk. There seem to be 6 extraneous issues. Take a look at those. I think this is what and they may disagree with that. Oh no, I think this, this is first, we will talk about it. I would say there was, and again, it depended on the law clerk, because there's some who are more reticent about giving you their feelings, others who jump all over you from the get-go. I probably liked that better. If you kept them for the second year, if they were able to stay for the second year, and most of mine were 2-year, turned out to be 2-year law clerks. The second year runs much more smoothly because they're comfortable. You're comfortable. But I think there's a lot of dialogue that goes back and forth between the judge and their law clerk.
Well, let me back up a bit on this and ask, what happened during this period? How were you involved in it in any way in getting appointed to this new court?
The Court of Appeals?
Yes.
Okay. I was really happy on the circuit court. I think once again, the Peter principle raises its ugly head. I was probably a better trial judge. I like the trial judge. My friend Barbara Keenan bugged me to death and said, "You really need to go on the Court of Appeals." She said, "You would love it." And I kept saying, "I'm not a writer. I don't want to do this. She said, "I'm just telling you, you would love it." And you have to look at things. There are times where things happen, and they may never happen again. So if you really want to do this at any time, you need to think about doing it now. And I'd been a trial judge at that point for, in the circuit court for 10 years, so 12 years. And I just thought about it, and I talked to Chuck, and I said, I've never done anything like this, and this is something that kind of interests me because you're making the law, and maybe once again you can have some impact on the law as a whole. What do you think? And he said, well, if you want to do it, we'll work on it. And the road to this appointment was the complete antithesis of before. When I started out, and I don't want this to sound sort of self-serving, but when I started out, there were about 10 people in the race, and then they all withdrew because they said it looked like it was mine. And so it became a complete piece of cake. And the interview I had with the bar associations was on the telephone, and it was just really, really easy. And I don't know why. I felt very fortunate, and that's what happened. I'd like to tell you I did something really fabulous to get it done, but really at the end of the day, I was the last one standing. Good to go.
Was there anyone or persons involved that were behind the scenes pushing that you know about?
Yeah, I mean, I think at that time, there were no women on that court, and I think they were looking for a woman. It was a Northern Virginia seat. I think that by that time the legislators felt very comfortable with me, and I think Dick Saslaw, who was a legislator up here, was kind of with the program. And the next thing I knew, it was over. So it was really a very different kind of deal, and I think it's true. It's never happened again. It probably would never have happened again. So.
And when you came on, they were still pretty much organizing themselves. I mean,
they'd been there. This was 92, and I think they started. The court really got going in about 86.
Mm-hmm.
Maybe it was a little bit more. The chief judge had died then. They had another one. When I came on, the court was a great court. I mean, I like to say it was the golden days. Fabulous, fabulous people on there. Sam Coleman, Jim Benton, Richard Bray, Larry Elder. I'm trying to think who else was on. Lawrence Kuntz and Norman Moon. It was just a wonderful group. And when I think what part of what Barbara Keenan was saying at the time was, this is such an intellectually great group, you're going to love it. And I did. I mean, we are all friends to this day. We talk all the time. It was a lucky move for me, I think.
When you first began on the appellate court, what kind of adjustments did you have to make?
Well, I think part of it was the isolation. You're isolated as a trial judge, but you're really isolated as a court of appeals judge. I mean, you only see, there are only 3 of you in your office at that time, yourself, your secretary, and your law clerk. And, I really am a people person, and I think you have to make it a point to keep in contact with the members of the bar, with your former colleagues, with your friends, or else you really can become a little isolated. And I thought that it took me a little bit of getting used to on that one. And then the idea of being a collegial body where you make decisions as a group as opposed to being the one that says you do, you do, you do, takes some getting used to. And there, you have to learn. You have to be more of a persuader, and you have to really have your ducks in a row intellectually so that everybody, you can get them on the page with where you think the case should go. So I think it's a very different world than the trial judge. It is a very different world. And it does take some getting used to. I can't say that, as I said, I'm probably not a natural writer, and I worked very hard. When I read my opinions in the beginning, they're very different than the ones toward the end. Hopefully everybody learns and gets better at what you do. But it definitely is a whole different intellectual keyboard. no question about it. And it's just, for me, it's a much more relaxed environment. I mean, you're not saying to somebody, okay, you go to jail for 100 years. You're looking at a brief on for something. And in some ways, it's not so good because it becomes a cold page and you kind of lose, the personal part of it. But it just is a different way of doing the job.
What was your approach to writing a decision? Did you like to write longhand with a pen or a pencil? Were you one of the early ones on the computer? Mm-hmm. And what was the thinking process that you began as you approached each of these cases?
Well, that's interesting because it probably varies from case to case. But with that being said, I usually started out with a pencil, a sharp pencil, lots of sharp pencils, and a legal pad, sort of getting out my own version of an outline. I mean, I always started with an outline. I think how the case comes, how the case should come out and what law goes with what issue in there. And I'd sort of lay that all out for myself. But then I did most of the writing on the computer. I could, hate to tell you this, I can type. I could, so it's my version of first word processing, and then I became much more computer oriented as the time went on. And then, of course, by the time we got all the LexisNexis and all that other stuff, and you could just take quotes and put them from one thing to another, it made it so much easier, for me at least, not to have to think, oh, did I put 3 dots where it was supposed to be? I mean, it just made it much easier. And then I had, my law clerks check everything, and I check with them. I don't want to, I can tell you that the person will be nameless who told me this, but at one point there was a whole opinion that was out there in which the word public was written as pubic. So, you need to not just count on, spell check. You need to really read it and have another set of eyes read it. And usually I had my secretary by the end, if after it was over, read it like a layperson. Because if it doesn't make sense for the person that has to read it farther down the line, we at least ought to have a question mark as what did this sentence mean? So it was really important to me to try and write clearly, almost as much as anything else.
Did you have that kind of dialogue with your colleagues?
In terms of how we write?
How you write, because, as you said, each person's
Everybody's
style
different.
Was very different.
Mm-hmm.
And so did you have that kind of dialogue? What are you really saying here? Or did you simply allow, just let them go ahead and write their opinions?
Oh, everybody wrote their own opinions. We didn't have, in terms of somebody else's case, if at the end of the hearing, we all agree that the case should be affirmed, and it was Judge Benton's case, he was going to write the opinion, and then he sends it out. And I don't micromanage his. I mean, if I think there's an error on the law, or I see some sort of grammatical, like you said, there, ERE instead of EIR, I would point that out. But everybody kept their own style. What I would do, and I would tell you, I think it's important to do. There are some judges who I think sometimes are gratuitously nasty in their opinions, and and I don't know that they necessarily mean to be, but they can say things that can be very hurtful to lawyers and judges when you don't really need to do it. I mean, you really don't need to do it, and those are the things I would just say, I'm not signing on to that unless you take this out of here. If not, I'll. And usually it got better. Yeah, but I mean, I've been on the end of it. I mean, I've been a trial judge before, and I know it's just not necessary to do that. I've been, an appellate judge, and the Supreme Court has done it. So I think it's important that, if something is really awful, then go ahead and hit them. But if it's just some, new lawyer that did something stupid, you just don't need to say, I think to them, you're the dumbest person that ever walked. And but those are the kinds of things that when you would say, what kind of dialogue would you have with your colleagues? If you disagreed with them, you might try and convince them, and then if not, I would say, well, I'm just going to write a dissent. And I would write a short dissent, trying not to be ugly in any way, just say, I dissent for the following reasons. If you really feel like that the analysis is wrong, then I think you kind of go to bat on that, because you don't want to have 100 concurring opinions. You try and get everybody on the same page with that. But I kind of feel like it's better not to sweat the small stuff.
Were there any particular cases that come to your mind where you really had to have an intense dialogue with your colleagues over a decision?
Well, I will say this. I can't, really, everybody works very collegially. Now, we disagree. I mean, people disagree on a lot of things. But I think everybody tries to be gentlemanly and ladylike, if that's a word, ladylike, in terms of dealing with one another. Because I never felt like my colleagues, any of them, even if I really thought they were out to lunch on something, weren't doing the best that they could. And maybe I'm the one that's out to lunch, I try and listen to what they say. If I'm completely, off the reservation, I want to know that too. And sometimes that happens. I mean, you can think you've got it all figured out, and then there's some little nuance you have just missed. That happens to everybody. But I don't think we've ever really, nobody yells or screams or anything like that. I mean, I think, when I became the chief with our court, everybody called me their mother, because I tried, that is really the way I dealt with my guys. And they were primarily guys. We ended up with more girls on there, women on there. But I think, to me, there's as much that needs to be said for sort of it goes back to Babe Levinson. You treat everybody as nicely as possible. If you just can't get everybody on the same page, just write a dissent. That's kind of where I ended up.
When did you decide to retire, and why?
Well, I've been a judge for a long time. And I sort of decided our court was changing a little bit.
Changing how?
Well, I think in some ways politics took more of a front seat than a back seat, and the legislature, and that has nothing to do with the kind of the quality of the judges, but the whole atmosphere just became more political. And I just decided that I'd been a judge for such a long time that when I got to be 60, that I was going to retire and do something else. And I really thought I was just going to teach at a law school. I don't know which one, but I thought probably, because I had taught some courses down at UVA while I was practicing, and I really enjoyed that. But before I retired, John McCammon talked to me about mediation, and I hadn't thought about it, didn't think it was anything that I would ever kind of want to do, and kept talking and talking and talking, and then I said, well, okay, I'll try it. And it turns out it's become like the best second career anybody ever had. I adore it. It's just been a great experience. So I guess maybe I was looking for something a little bit different. I thought it was time to let somebody else come in the curve. Maybe I'd done most everything I thought I could do there. I didn't want to go to any other court. I liked my court. But I just thought it was time to maybe take that next step. See my grandchildren, play more tennis, do that.
And how often do you still work in your second career?
A lot.
I'm talking about like daily. Is this a daily thing?
Well, I try and do 2 days a week, but sometimes it becomes more than that. But I really want to be retired. I'm trying to figure out how to get my schedule so that it's not quite so much like it's every day. This week, for instance, it's 3 days. And I don't know how that happened, because I try not to do that. But I think in the fall I'm going to say I'll just work 2 weeks a month and take 2 weeks off. And then, they set the cases, however it is, whatever's out there. But I love this. I mean, you're solving people's problems, keeping them out of court. Almost everything settles. And I just think it's terrific. I love it.
Final question. Your goal when you were young was to make a difference.
Mm-hmm.
Have you made that difference that you sought to make?
I think probably the best I could. I can't say I'll be the greatest judge that ever was in the history of Virginia, and I don't think I'll probably ever write the best opinion that anybody will ever write. But I guess what I would say is I feel like I had a chance to do what I wanted to do. How many people can say that? You know, I had 3 jobs, that actually now 4, that I absolutely loved. There was never a day that I didn't want to go to work. I think probably for me, you know, I never, I always just say, as I said before, you know, I always think that I'm sort of ordinary. So for me to have done anything is like this, to me, is a great gift. And I feel like I've had a pretty good run. So I'm not at all unhappy about anything that's happened in these past almost 30 years now. I feel really lucky.
Do you think it's time to start writing a book about how to be a good judge?
Isn't that interesting? Probably everybody has a different answer to that. I still talk, I mean, I talk to people all the time about judging and, you know, law and one thing or another, and I guess probably the same things I've said to you, maybe not in quite as an expansive manner. I talk to young lawyers who want to be judges. You know, the Virginia Women's Attorneys Association has had, you know, do you want to be a judge for years? I usually do that. I just think there's so much that, this is why I think this project is fabulous. I'm sure if you talk to 20 different people, they're all going to tell you different things that were their motivating things, or what they feel like they've accomplished, or how they would do things. And probably the more you put out there, the more that somebody who's maybe a little bit like me would say, oh, well, maybe I can do that, you know, but I can tell you, this has been a fabulous career for me. I love Virginia. I'm not a Virginian by birth. I feel like I was, you know, lucky to get dropped here, and wouldn't give it up for anything.
Thank you so much.
Well, thanks for doing this. I enjoyed it.